the docketing case.
The case is now being recorded.
Good afternoon. For the record, this is December 14th, 2022. Our next case here at the Appeals Court is docket 22P82, Commonwealth versus BODDIE. We'll hear first from counsel for the appellant. On behalf of the Commonwealth, Attorney Linehan.
Good afternoon, Your Honors. May it please the court. Richard Linehan representing the Commonwealth. If Your Honors please, this appeal was brought by the Commonwealth challenging the decision of the Superior Court judge allowance of a motion to suppress on a quantity of drugs that were seized on this defendant as a result of this particular motor vehicle stop. The judge in that case did not rule on any exit orders or subsequent search of the vehicle or the defendant in this case, as he ruled that the stop of this motor vehicle was not justified, so that therefore everything that flowed from that stop was suppressed, and included in that the quantity of drugs in this case. This particular case involves a stop of a motor vehicle for the failure to use a turning signal when taking a left-hand turn at a four-way intersection. The defense would characterize this reason for this stop as pretextual in nature. However, whether it was or wasn't pretextual, that is not relevant in Massachusetts. It has long been established that in Massachusetts, police motives for making a motor vehicle stop are, again, not relevant. Massachusetts uses, as the court is aware, the authorization test as described in Commonwealth versus Santana in 1995. And also most recently in the case of Commonwealth versus Douglas in 2015. That brings us to the stop of this particular motor vehicle by an unmarked police car, actually a pickup truck in this instance, at the intersection, actually a four-way intersection of Spring Street and North Warren Ave in the city of Brockton. Both of these streets, Your Honors, are one-ways with electric traffic signals also at the intersection. And in this particular intersection, the left-hand lane of Spring Street is designated for left turns only.
So Attorney Linehan, let me interrupt you. We have a pretty good grasp on the facts of this case from the record. What case law do we have analyzing section 14B, and in particular, analyzing the language that states, quote, which would affect the operation of any other vehicle?
Yes, if Your Honor, please, you're familiar with 14B from the briefs, and 14B illustrates that or states that every person operating a motor vehicle before stopping said vehicle or making any turning movement which would affect the operation of any other vehicle shall give a plainly visible signal by activating either their brake lights or directional light in this particular case. I would point out that the statute does not say any vehicle ahead or to the right or to the left. It states specifically any vehicle. Clearly, there is no dispute in this case that this vehicle took a left-hand turn without signaling. That is not in dispute. Right.
So as I said, we're aware of the facts. My question is, what case law, what precedent do we have that analyzes the words which would affect the operation of any other vehicle?
Yeah, and Commonwealth would rely in our brief on the case of Commonwealth versus Rodriguez, an appeals court decision. It's a Rule 128 opinion. Therefore, it's unpublished. It doesn't have precedential value, but it's certainly persuasive. Commonwealth would argue that that case is very much on point with this case. In Rodriguez, the defendant in that case, it was again a turning signal case, was making a right-hand turn with no traffic around, except for, in that case, a marked police car that was directly behind it. Although Rodriguez didn't involve the failure to signal from a dedicated turning lane, the court noted that the police cruiser was one car length behind the defendant's vehicle and made note of that. In the present case, our police
But isn't the panel's mention of it not being a turn-only lane, isn't that significant? I mean, doesn't that show that the panel put some weight on that?
Well, the Commonwealth would argue that whether or not it's a dedicated turning lane, a person does not necessarily know that a vehicle ahead of them is actually going to obey that particular turning signal. I mean, how often have we seen in our own experience cars in dedicated lanes not obey and go straight? And we may have been in that situation where you kind of get caught in a turning lane by mistake, can't get out, and have to go straight. So the Commonwealth would argue that a vehicle, by not signaling, may be signaling their intention to go straight. It's not clear. Certainly, if they're signaling.
Sorry to interrupt you. I'm
Go
sorry.
ahead.
This is why I love Zoom so much. But the the statute doesn't say which could affect the operation of any other vehicle. It says which would affect the operation of any other vehicle. So what do we take from that?
Well, I would take from that it's an objective test. Certainly, vehicles traveling behind a vehicle are going to be much more affected by the actions of the vehicle in front of them than, say, a vehicle traveling in front of the subject vehicle. The vehicle traveling in front of the subject vehicle is not going to be affected at all by the actions of the car behind them. However, the car traveling directly behind and within approximately one car length is, Commonwealth would argue, would be affected, whether that vehicle takes a turn and goes straight.
It says a turn signal is required before making any turning movement, which would affect the operation of other motor vehicles. So your hypothetical of going straight wouldn't even apply because that's not a turning movement.
But that's the purpose. The Commonwealth will argue that's the purpose of the signal, to indicate that they're actually going to obey the law and make that turn.
I agree with you that it's probably best driving practice to use your turn signal when you're turning left. But the words of the statute say a turn signal is required before making any turning movement, right? So if you're going straight, it doesn't require you. You understand what I'm saying.
I do. And I'd also point out to the court that the statute does not give any exception for dedicated turning lanes. It doesn't say you don't have to use your turning signal if you're in a dedicated turning lane. It just says if you're going to make a turn that would affect any other vehicle, you're required to use your turning signal.
On the facts of this case, which vehicles would have been affected by the turning left?
Well, Commonwealth would argue that this case, like Rodriguez, the police car is approximately one car length behind the defendant's vehicle in this case, as it was in Rodriguez. And in Rodriguez, the appeals court in that case felt that the police vehicle would be affected by the failure to use the turning signal, albeit it wasn't a dedicated lane, but there is no exception in the statute.
How is the movement of the officer's vehicle affected by the turn?
It's hard to say whether it would be or wouldn't be. It's putting that driver on notice that the vehicle in front is going to take an action, whether the sign requires it. Go ahead, Your Honor, I'm sorry.
It says would affect the operation. So I'm just trying to ascertain how would it have affected the movement of the vehicle. I understand the notice argument. And like I said, I agree that we should,
it may not affect it, but I don't think we have to have a situation where the vehicle traveling behind would have to slam on their brakes if they didn't get a turning signal or did get a turning signal. I don't think that's what the legislature envisioned when they designed that statute. They were trying to give notice to, in this case, drivers driving behind the subject's vehicle, that that vehicle was going to take an action. And again, there are no exceptions written into the statute for dedicated turning lanes. And as we know, people don't always obey traffic signs. So it's a Commonwealth position that this court should adopt the unpublished opinion in Rodriguez in that analysis. I mean, the facts are almost exactly the same, except for the fact that we have a dedicated turning lane and Rodriguez does not.
Attorney Linehan, let me ask you a different question. Assume arguendo, and I truly mean arguendo. Assume arguendo, we agree with you and accept that the stop of the vehicle was valid. The Commonwealth presented evidence, so I want you to further assume for purposes of these next questions that we agree with and accept everything that the witness testified to at the motion to suppress, okay?
Yes.
And let's assume that the exit order was okay. And let's assume we determined that the handcuffing of the defendant was okay. Let's even further assume that it was okay for the officer to retrieve the wallet. My question for you is, with those assumptions still in mind, what is the basis for opening the wallet, seeing the contents of the wallet, taking out the bill, and opening it?
On that particular point, I'm not prepared to argue the basis for that. It's interesting to note that the motion judge did not make any rulings of law in that regard.
Correct, but we are able to affirm on any basis apparent from the record, I believe. And so my question remains, I understand your position, but I'm asking you. It seems to me that the officer would need probable cause to be able to search the wallet, and more importantly, to search an item taken out of the wallet. Because this isn't a reasonable suspicion frisk. There's no risk of a weapon being wrapped up in a dollar bill stuck into a wallet. So how could there possibly be probable cause not only to open the wallet, but to search it, take out a bill, and then open up the bill and search that?
Well, as I recall, the facts of the stop, police officers did have certain information which gave them suspicion that there may be some drug activity. They also made observations when they stopped the car and looked in, and based on conversations, as I recall, the defendant was asked if he had anything of an illicit nature, and he indicated that he had some fentanyl. That's how I recall the facts.
I think those facts came out after that admission, and Attorney Levin will correct me if I'm wrong, but I think that was elicited after they took out the dollar bill and opened it up. So,
Well,
yeah, I'm just wondering, if we accept everything the officer testified to as true, how could there conceivably be probable cause to search the bill within the wallet? Never mind searching the wallet itself, but searching the bill.
Well, searching the bill, it would, in that particular case, in this particular case, I believe it was a rolled up bill or folded in a certain manner, which would indicate perhaps some illicit contraband was inside that.
What about the search of the wallet?
The search of the wallet, again, there were no findings of fact made on that on the record, and there were no rulings of law.
Let's say it was raised by the defendant, and let's say we accept everything that the witness said is true. What justifies the search of the wallet?
I don't have a good answer for the court on the search of the wallet. And again, the motion judge in this case stopped his analysis after the stop. I would suggest that
it was raised, and it seems like the prosecutor at the trial court level kind of passed over the question of the search of the wallet. There was no evidence offered or argument offered on that point. So, and what findings could be made?
And again, well, I would argue that it should be remanded back to the motion judge for additional findings of fact and rulings of law on those issues, as the motion judge did not go beyond the stop of the vehicle in his
What-
rulings of law.
What findings could be made? What findings could plausibly be made on the opening of the wallet that would justify the search of the wallet?
You know, well, looking at the facts, could have been furtive movements in the vehicle. I'm
But
not
there was no
sure.
testimony to that. So that the officers already testified. So we assume we accept everything the officer said as true. And your time's about to run out, but I'm going to give you time to answer this. So assume that the judge said the findings of fact are I credit absolutely everything the officer testified to. Can you, akin to Justice Shin's question, can you give us a scenario based on those facts where there is probable cause to search the wallet and then take out the bill and search that? It seems to me that has to be probable cause. And I'm wondering what facts would give probable cause for that search.
Well, I would argue that looking at the facts of the case, the defendant, they did notice him reaching for what they found was a pocket knife within the same pocket, I believe. And
that justified the exit order.
Correct. But it came out of the pocket. The wallet also came out of the pocket, as I recall. And he was, pat first for any additional weapons.
So go ahead.
There was a conversation, as I recall, about his ID, and the ID had to be extracted from the wallet. And he was allowed to retrieve that wallet and produce the ID. And when he had the wallet going out to produce the ID, the bill in question, I believe, was viewed by the officer, and it looked suspicious. And the further analysis of that indicated that further inquiry should be made as to the presence of any additional drugs, and that's where the ensuing conversation regarding any additional drugs in the defendant admitted to fentanyl.
Okay, understood. Thank you. Let me just make sure, Justice Shin or Justice Smith, any further questions for Attorney Linehan? Okay. Seeing none, thank you very much, counsel.
Thank you, Your Honor.
I'll hear from counsel for the appellee, Attorney Levin.
Thank you, Your Honor. Good afternoon. May it please the court, Patrick Levin on behalf of James BODDIE. I just want to start by saying that I'm sorry I couldn't be there this morning. I want to thank ADA Linehan and the court for being so accommodating. The police conduct in this case betrays a total disregard for the constitutional rights of Mr. BODDIE and his girlfriend, Aisha Dunn, who was driving the car that evening. Affirmance of the suppression order is required on any of half a dozen independent bases. I guess I'll begin by just clarifying the record a little bit. Mr. BODDIE never reached for a knife. There was no testimony about that at all. He was reaching for his wallet in response to a request for his identification, and the officer saw a lawful pocket knife in his pocket, at which point he ordered Mr. BODDIE out of the car, handcuffed him, and advised him he was being detained. In addition, Mr. BODDIE consistently denied possessing fentanyl at all times during this encounter. He was asked whether the substance that the trooper found in his wallet was fentanyl, said that it was coke or powder. It was not fentanyl. So with those clarifications, I will move to the only question that has been briefed by the Commonwealth in this matter, which is the turn signal statute. The statute does not require a driver to signal a turn under the circumstances in this case, where there is no other direction the driver could go and no traffic that possibly could be affected by the turn based on the traffic layout of the road under these circumstances.
So are you suggesting that if you are in a left turn only lane or right turn only lane, and you are making, let's say here, you're in a left turn only lane, you are not required to use a signal?
At least Under the circumstances present here, where no oncoming traffic is able to come from any direction, because it's a one-way road, Spring Street, there's no oncoming traffic on Spring Street from the other direction that could be affected. The traffic, there's also a one-way on Warren Avenue going southbound, so there's no northbound traffic that could be affected. And the traffic southbound on Warren Avenue is stopped at a red light. So there's no traffic there that could be affected. If you look at the two lanes of Spring Street, a car driving in the right-hand lane could not possibly be affected by the turn because it would either be turning right or going straight, and it would not, there would be no chance for a turn to affect it. And so the only possible location that a car could be for it to be affected possibly by this turn is directly behind Ms. Dunn in the left-hand turn lane. But of course, any car in that position also only could lawfully turn left onto North Warren Avenue.
The statute doesn't say, I'm sorry to interrupt, but the statute doesn't say lawfully. And I think a turn signal is not only designed to arguably prevent accidents for people who are operating lawfully, but designed to give notice to perhaps someone who is acting unlawfully or acting negligently. So for example, assume the car behind the car in which the defendant was traveling was in the left lane only lane as well, but didn't know it was a left lane, didn't know it was a left turn. And suppose further that they ran into your client's car because there was no signal.
Well, Your Honor, I guess my response to that is I'm not sure under the facts of this case how that would happen, because Ms. Dunn's car cleared the intersection in exactly the same amount of time by turning left onto North Warren Avenue as it would have by continuing straight on Spring Street. There is no way under the facts of this case that a car traveling behind her could be affected.
Okay, so assume in this case that your client is in the left-hand, left-only turn lane, doesn't signal. Car behind her doesn't know it's a left lane only. They're not from the neighborhood, they just don't know, and they're not paying attention. And because there is no signal, this is the second car accelerates and strikes your client's car as it's making the left-hand turn. In the scenario I just gave you, would that be a violation of 14B?
I don't believe so, Your Honor, because that collision was not caused by the turning motion.
Well, the statute doesn't say cause. It says which would affect the operation of any other vehicle.
But it's not a turn that would affect the operation of the vehicle is what I'm saying. It's possible, I suppose, although on the facts of this case, if you look at the video, it's not factually true. Ms. Dunn does not slow down before making the turning motion. And so if a car behind her had accelerated and rear-ended her, it would have equally rear-ended her, but if she had not turned and instead had continued straight at the same velocity.
Well, again, assume for purposes of my hypothetical that as she's turning, the car behind her strikes her, at least in part because there was no signal. It affected the operation of the other vehicle, the absence of a signal.
Your Honor,
a turning movement.
Your Honor, I think at this point we're pretty far out on a hypothetical ledge here.
The purpose of the hypothetical is, I don't know that we want a rule that says if you're in a left lane only turning lane, you don't need to use a left-hand signal. How far the hypothetical goes, I don't know. But at least I think we need to come up with a rule, or at least an interpretation to the extent one isn't already out there in our case law, or at least in our published case law.
Well, Your Honor, in terms of the case law, I just want to note that although Rodriguez is not precedential, the panel there did find it quite significant that there was nothing in the layout of the road that gave the driver behind Mr. Rodriguez notice of the turn. And so to the extent that any case law does exist on this point, I believe it supports me. But moving beyond the Massachusetts case law to the cases in other jurisdictions that I've cited in my brief, In those jurisdictions, the statutory language is, if anything, broader than our statute, requiring a signal if a turn may affect the operation of another vehicle as opposed to a would affect. And those jurisdictions give a construction that I think also supports my argument in this case, namely that there needs to be a reasonable possibility that another driver would be affected by the turning motion. And I do want to emphasize again that it's even in your hypothetical, I believe it would not be the turning motion that would affect the operation of the other vehicle. Your hypothetical seems to me to suggest that it's the speed of the car that is causing that collision and that would affect the other driver's decision making. But
again, the language says affect, not cause. But in any event, moving on, could you help us with the word would? Perhaps the unfortunate use of the word would, but the word would in the statute in 14B. It almost seems to suggest that there would need to be an accident or evidence of someone slamming on the brakes. And that doesn't seem to me to be necessarily a reasonable interpretation, but we're also stuck with the plain language of the statute. Can you help us with that?
Well, Your Honor, what I would say is I agree that the court must give effect to the language that the legislature enacted. And I also do want to emphasize that to the extent that the court discerns ambiguity in that language, it should err on the side of a narrow interpretation of the statute, because although it's not a criminal statute, it is a statute that results in stops and searches and fines. And it's equally appropriate to apply the rule of lenity in this context. Drivers need to have fair notice of what's required of them, just to the same extent that people reading, say, misdemeanor statutes do. So to the extent that there is any ambiguity in how to construe this, I think that the court needs to construe it narrowly in order to ensure that that police aren't making stops and writing tickets based on conduct that the legislature hasn't clearly proscribed. I do want to
on the other issues you raised, in particular the search of the wallet.
Mm-hmm.
Do we need findings from the judge to resolve that question?
You don't, Your Honor. This court, of course, can affirm on any basis that's fairly supported by the record. And it's the Commonwealth's burden to put in evidence that would justify a warrantless search or seizure. So, I'm certainly, for purposes of this case, I'm perfectly willing to accept the trooper's testimony in toto. He clearly described a series of unconstitutional intrusions on Mr. Boddie's liberty, beginning with, as I mentioned, they ask him for identification. He reaches for his wallet. They see a pocket knife in his pocket, which is lawful to possess, as the trooper admits. And the trooper immediately orders him out of the car, handcuffs him even before a frisk, advises him that he's being detained. At that point, Mr. Boddie is under arrest. The Commonwealth has never at any point in this litigation suggested anything that could justify the use of handcuffs in this context. I do want to point the court to the case that I provided in my 16L letter. It's a Seventh Circuit case from September that contains a brief but I think excellent discussion of the circumstances under which handcuffs convert a Terry stop or a traffic stop into an arrest. And they say that the officer has to believe reasonably that the Terry stop could only be effectuated safely by using the handcuffs. There's nothing in the record of this case that even remotely suggests that. The handcuffs transform this into an arrest. And that's especially true when you see that they advise Mr. Boddie that he's being detained and then don't even uncuff him after they frisk him and don't find any weapons. And then, of course, the entry into the car to retrieve the wallet is unconstitutional. I want to point the court specifically to Sheridan, which is the most recent case in which the SJC has discussed this issue. And they're very clear. We have never held that officers may routinely enter vehicles to acquire driver's license and registration documents. Generally, the officer may simply direct the driver to retrieve his identification from the vehicle. Of course, that wasn't done here because Mr. Bodie was still unlawfully arrested and in handcuffs. The search of the wallet similarly is unconstitutional. The wallet should have just been handed to Mr. Bodie to retrieve his identification. I think that's clear from the Pagan case, which was relied on the Commonwealth below, but erroneously. And of course, they didn't hand him his wallet to retrieve his identification because, again, he's still in handcuffs. And then once the officer opens the wallet, there's absolutely nothing to suggest why he might be able to then flip through its contents, take a dollar bill out of the wallet, unfold the dollar bill. Now that's a search without a warrant, without probable cause. It's unconstitutional. Everything that was found as a result of this traffic stop must be suppressed.
So let me ask another question. I'm going to ask you a hypothetical. I asked Attorney Linehan a hypothetical, so I think I should give you the same opportunity to answer a hypothetical. And let me preface this by saying I know you are not going to agree with the assumptions, and you win first prize if you don't tell me that that is not this case. So here we go. The hypothetical is as follows. Assume that the police were constitutionally justified in taking the wallet off the seat, in opening the wallet, just those two things. Further assume that the officer testified that to him, the way the dollar bill was seen within the compartment in the wallet, to him had immediate evidentiary significance, i.e. it's a way that in which cocaine or other drugs are sometimes stored.
Mm-hmm.
Assuming those facts, is there probable cause to take out that dollar bill and open it up and search it?
So, Your Honor, the answer is no, but I will go one step further and assume an additional fact to the Commonwealth's benefit, which is to say, even assuming there was probable cause, the search is still unlawful without a warrant.
And what's the reasoning?
Well, Your Honor, a warrantless search is presumptively unconstitutional, and the Commonwealth didn't provide any evidence of exigent circumstances of any kind.
Under the immediate evidentiary significance doctrine, is a warrant still required?
Yes, Your Honor. And I cite in my brief a couple of cases out of I believe it's the 8th or the 10th Circuit, which in turn cite to Horton versus California for the proposition that even if the incriminating nature of evidence seen in plain view is immediately apparent, if that evidence is a closed container, the plain view doctrine supports only a warrantless seizure of the container, at which point a warrant must be retrieved.
And your time has expired. Let me see if my colleagues have further questions.
Nothing further.
Seeing none, I want to thank both counsel for the helpful